government or military has failed to meet the duty that they owe you as a soldier, that they are taking you to often terrible conditions, either by worsening your conditions, for instance, by not offering you adequate psychological care or by making tactical decisions that place you in greater risk than is acceptable, then you ought as a soldier be able to have recourse and seek compensation. But even if you are not able to get that compensation, there are still, as I'm going to tell you in a second, benefits to opening up that kind of discussion, to discussing and questioning what is an adequate amount of risk for somebody to put a soldier into, what is okay for them to be able to opt into, for them to have that kind of information, for society to have that kind of information is good, whether or not these individual cases always succeed. And I'm going to do a few things in this speech. Firstly, I'm going to tell you why this just kind of principally makes sense to give soldiers this right. Secondly, I'm going to tell you why they will often succeed. And then finally, I'm going to tell you why, even if individual cases sometimes do not succeed, why it's still good to have this available. Firstly, on why this just kind of principally makes sense. I think it is just kind of obvious that the government and the military has a duty of care that it owes to its soldiers like any other employer does. And note that also, as I'm going to tell you in a second, the fact that this is kind of an intuitive link to make also has practical implications for the trial process, but also what the public's response is likely to be. Like, it is not likely to be responded to with outrage or shock by the general public, this notion that the military and government owes soldiers duties of care. But also note that governments and militaries are often held accountable for the treatment of civilians and soldiers, even of the opponent nation. So it is bizarre that they would not be held accountable for similar or worse treatment of people from their own nation, and that is likely that should apply kind of equally to soldiers of your own military as you owe that duty to any other person who you involve in your warfare. So this obviously just kind of principally makes sense. But why will these often succeed? Note, obviously, even if this is a new area, there are likely to then, be lawyers and education to fill that gap soon, and likely to be people who specialize in this. Firstly, note that it won't be particularly hard to bring these cases or to find general public, for instance, support of bringing these kinds of cases. That is because of a generally nationalistic sentiment in many countries towards veterans. Note that nationalistic sentiment doesn't look like wanting to protect your government from being sued or whatever. That is not how that actually manifests. Your nationalistic sentiment often most concretely manifests as sympathy towards veterans who've been, fighting a war for your people, for your country. That is how that often looks, and therefore it is likely that people are going to generally be supportive of soldiers who want to bring these cases. Also note that it is uniquely easy in these kinds of instances to get a critical mass of people for like a class action, because often these decisions impact the swathes of soldiers, and what that is likely to mean is that even if not all of them are on board, you do not need all of them to be on board. You only need a small portion of the incredible masses of people who've been impacted by this to want to come forward, and that's why it's uniquely easy here to get a critical mass that is likely compared to like other class actions or things like that. Secondly, I would note here that I don't think the evidentiary or legal burden is super high, noting firstly, obviously you only have to prove this on balance, but I think it's also kind of, you won't struggle with many of the stages of proving this. That is, to prove negligence, you obviously have to prove things like a duty, but that is likely to be straightforward. So the only real evidential burden for you is likely to be that you have to just bring enough evidence to show they breached that in some way. And often those things are going to be relatively easy. Like, yeah, maybe the government will try to deny it, but often it's just things that are objectively true, like that the soldiers did not get adequate, like psychological care, like that they did not have access to enough, psychologists or whatever. That is just kind of like an objective piece of evidence that those soldiers can bring, and therefore it is unlikely that it will always be very hard to meet that kind of evidential burden. Kind of preempting that, I assume will say, well, the government will now just have more incentive to cover up this kind of stuff. No, firstly, like, I know that we say this in debating, but it's not like the extent to which you can cover stuff up does not just kind of linearly or exponentially increase. Like, you can't just increase how much you are covering things up. But also note that the government is already likely to have incentives in the status quo to cover things up to an extent, but it is now more difficult to do that in a way. It is difficult to increase the extent to which you cover things up without leaving blatantly obvious gaping holes of information, which will only be publicly seen or will be known once we have this kind of a process in which we can investigate and kind of look at the facts. Once we are able to emerge, once we are able to study those facts, that is when we can see that there are holes in the information. That is when we can see there are things that look like cover-ups. That's why it's unlikely that just the fact that the government wants to cover things up will mean that these cases will not succeed. Finally, though, why is it still good even if they do not always succeed? I'll take one from Opening.
Are there instances in which the military must act in a risky way in order to save the most lives?
So, okay, so obviously that is true, but I think the court is able to also even make that way up. That is, in current negligence cases, there are recognitions that there are other factors that may mean that you cannot, for instance, if it were true that every time there's a risk, we must take the most extreme way to prevent that risk, then you would just have like mattresses on the floor everywhere. Obviously, the court does not mandate that you have mattresses or like, you know, stuff on the corners of the tables in case I stab my hip on it. The court is able to weigh up the fact that there are external factors that may require attention. They have done that with negligence cases in the past, just like in any other negligence case. I do not see why the court is going to be incapable with the kind of information that they will have available to them, because they will obviously call on things like expert witnesses, like military tacticians or things like that, to kind of gather that kind of information to make that way up. The court has national interests at heart as well, in the sense that they obviously do not want to impose ridiculous burdens on the government and on the military, and they are likely to have those policy concerns in mind when they are making that way up. It is unlikely that they will be uniquely unable to do that in these kinds of cases, and they need to tell you why. Why is it still good even if these do not always succeed on a case-by-case basis? Firstly, the general fact-finding and investigative process and the general increase in transparency and information is likely to be good whether or not that individual case succeeds, because it is likely to open it up to public scrutiny in a way that it otherwise maybe wouldn't. To note that often these issues are kind of invisible unless you are somebody who has literally been a soldier and has experienced them yourself, and it is good that it is something that will now more publicly be known about and probably get more public sympathy around. And that obviously I think also empowers soldiers to demand reform, even if not individual instances of compensation, if systematic failures to meet the government's duty are more publicised and are more widely known about. Secondly, there is a deterrence effect, because it is obviously easier to not commit certain types of harms, like bad conditions, than to try and cover it up later. Note that this doesn't rely on the government being scared that the soldiers will win. It just relies on the government being scared that this trial will occur and there will be an investigative process where they will be subjected to scrutiny. That is likely to create a deterrence effect. And finally, as I flagged, I think that the discourse around what is a reasonable amount of risk for a soldier, which Ollie actually talks about, is one we should be having more in society, more publicly, that requires more attention. We get that under our side, and that's why we must do this.
The first thing I'm going to explain in this speech is why this policy would foreclose on the ability to pursue other forms of meaningful redress for soldiers where they have been wronged, and then I'm going to secondarily explain why this would impact military functioning in such a way that more lives would be lost. To the first point, there are two ways in which this would foreclose on the opportunity to pursue other forms of meaningful redress. Firstly, by making the military never use military courts, and secondly, by meaning that we are unable to pursue structural change to the military as easily. To the first point, why we would no longer pursue justice in any form in the military. To our minds, this encourages the military to pursue three forms of obstructions of justice. Firstly, and most importantly, they will not bring cases to military courts where they otherwise would, for the reason that when they bring the cases to the military courts, they must collect all the evidence that directly inculpates the military and means that they will be the ones having to pay millions upon millions of dollars to those soldiers into the future, which means they are unlikely to bring cases to the court in any instance. And as the Prime Minister so correctly points out, it doesn't matter the likelihood of that actually occurring in the instance. The fact that they are scared of that happening at all means they will not bring the cases to the courts in any case. But secondarily, even if they are able to bring them to military courts or to these other forms of courts, they will destroy the evidence. And Prime Minister tries to preempt this by being like, oh, well, there'll be still some evidence and you can't destroy all the evidence. One, that is not true in all instances. In some instances, there are 2 or 3 key pieces of evidence that are easily destroyable. At the moment, an incentive does not exist to destroy them. But secondly, it can get worse even to the extent that they are able to have some evidence. The fact that we do not have all evidence means the cases can't be tried as easily in the military courts where we would want to. But thirdly, we would tell you the military is now more likely to silence soldiers than they were before, both in the form of intimidation and punishment for when they do speak out, but also in extreme cases, like in the theatre of war, literally killing soldiers that you think are going to bring cases against you and disrupt the functioning of the military because you fear what it will do to your unit. All of which means we close off the most meaningful avenue for justice, which is being able to bring these cases to the military court where commanding officers can be punished, where the cases can be heard, and where justice can be pursued. And all of that is unique to civil suits, yeah? Because the problem is that all of that doesn't apply to military courts for 3 reasons. Firstly, the military and commanding officers have a far greater degree of trust in military courts, which is the reason why they exist in the first instance, because they refuse to cooperate with civil courts, because they believe that the circumstances are so different that they could never meaningfully have their cases tried in those instances. Secondly, even if commanding officers in both worlds would want to destroy evidence, it is only in their world that the military at large would want to participate in the obstruction of justice, because the military is now being held accountable, whereas previously it would be individual soldiers and individual commanding officers. But thirdly, because the evidential burden is much lower in their case, which is to say they only need to prove that something likely happened as opposed to happened without a shred of doubt, which means that people have a greater incentive to destroy evidence in the first instance. All of that means is that the most meaningful form of justice, which is sufficient in the status quo to punish these officers and is sufficient to ensure that we have just enacted, is closed off altogether. They don't get more justice, they get no justice on their side of the house. The second thing we're going to prove is that you can't pursue structural changes as easily that would help people like veterans who clearly have been wronged by the military. Because the problem their side of the house the problem generated by their side of the house is they send the narrative and they make people believe that the people who need support from the military, the people who have been wronged by the military, can get support through things like suing people where wrong has occurred. And the people who don't need that help, well, they don't need it, so we don't need things like benefits for veterans. We don't need to do things like make their lives easier in other ways, which means that we create a narrative that the military is able to co-opt, and members of the left and the right are able to co-opt, depending on the country and depending on the military context, to say, well, we don't need to reform the military, we don't need to reform veteran benefits, they can already get the benefits through this system. But as I've explained, that system is unlikely to get them those benefits because of the obstruction of justice in the first instance. Which means the extra publicity they generate for the wrongs against citizens, against soldiers, is actually useless to their side of the case. Now, they try to trade this off by saying, well, this will make commanding officers more responsible in wartime, which will mean that you get fewer instances of needing recompense for victims. We tell you that the incentives largely already exist to not screw over your soldier. 5 of them. Firstly, military court exists, you don't want to be subject to that. Secondly, you care about your soldiers, they are part of your family. Thirdly, you don't want to incur reputational damage from within the military because it means you won't get a promotion. Fourthly, the military at large has incentives to structurally make sure these things don't happen so they don't look like fuckwits to the general public. And fifthly, armies need their soldiers to feel supported and cared about in order for them to be loyal, in order for them to properly participate in military operations. So, they don't provide a large additional disincentive for people to not participate in absolutely egregious behaviour. Those already exist. They add an extra incentive, but not sufficiently so that they would meaningfully change the situation at the moment. So the premise of their case is misguided. There doesn't exist a huge amount of screwing over soldiers in every single instance. The extent to which soldiers are screwed over are a necessary function of war, as I will explain later. But what about the instances in which commanding officers have committed true wrongs? What we're going to explain to you is that is much better resolved under our side of the house, where we are able to pursue things like military justice, something they are never able to pursue. I'll take closing.
Often military courts can do things like strip you of your rank or discharge you from the military. Why wouldn't the incentives to cover up still be present for those journalists who don't want to receive those consequences?
So I've explained, and you're right that it exists to a small extent, but it doesn't exist to the same extent as I explained before. But more importantly, the crux of our case is that the military as a whole has the incentive to destroy evidence, and they have a greater capacity to, whereas in your world, it's only the individual officers who have the incentive to destroy evidence, which is why things get much worse on your side of the house. The final thing I'm going to explain is why this policy would impact military functioning in such a way that it would end up with more lives lost in the theatre of war. The first reason for that, and the most important, is that commanding officers will proceed in more risk-averse fashions in all instances, as opposed to just the instances in which they think it is appropriate. And we tell you that failing to act riskily can lead to death, and often does lead to death in instances of war. Playing it safe when you are in a house, say your soldiers are locked in a house, and you need to go out and you need to fight to have any chance of survival. You are now unlikely to ever do that because you can't be punished for the omission of failing, the omission for acting. You can only be punished for acting in the first instance, which means that you foreclose on any possibility for people to act riskily when they need to, which not only impacts the micro scale, like I discussed earlier, of individual military operations, but also the macro scale in that it means you are less likely as a military as a whole to intervene in situations where you would need to intervene, and that would necessarily save the lives of citizens. Secondly, this policy would sow disunity amongst the military, and it would create another gap that exists between commanding officers and soldiers, and another way for threatening relationships between the two, which means you're less likely to have trust, less likely to have loyalty, and less likely to have people give crucial information to one another to make sure the military proceeds in a proper fashion. But finally, also in these civil courts, information has a greater chance of leaking to the enemy that would reveal structural weaknesses from within the military as a whole. All of which means that the military is unable to proceed in the fashion that would save the most lives, because their incentive is always towards acting in the fashion that is going to avoid these suits, as opposed to the fashion that is going to make the world a safer place. All of which means they don't get justice and they make war a more dangerous place. That is why we oppose.
The problem with opening opposition is that they assume the current hidden consensus of military courts that there are certain things that commanding officers can and can't do is the correct decision. It's the decision the military would want. It's the decision that individual soldiers would want. And importantly, it's also what broad-up people would want if that was brought into the limelight. We disagree with that at Opening Government. We say that the very structure of military courts that claims in some way that the military can just decide what's best for soldiers, that the military can take justice into their own hands, is exactly the kind of thing that stops reform from happening. It's exactly the kind of thing that stops people being able to agitate for instance, better treatment of women in the military or better treatment of veterans going into society. And we absolutely oppose that outside of Opening Government. The first question I'm going to ask is, do soldiers have a right to this recourse? And is it, I guess, something that would this recourse be meaningful? The first thing I'm going to explain here is that military courts are not sufficient. And I think the fact that opening opposition wants to say, like, well, sometimes things happen in military courts, but isn't necessarily able to, like, you know, discuss the inner workings or whatever of them, is systematic, is revealing of the fact that military courts function as something very internal. They're not democratized, and we think that often they're bad. So for instance, when opening opposition says things like, well, of course there are sacrifices you need to make in war, or of course war is shit. Yes, to some extent that is true, but that should not just be the unspoken consensus of military courts when viewing, for instance, whether or not failing to provide psychological care is sufficient, or putting someone in a situation that's likely to cause a large amount of PTSD for no particular reason is sufficient. These weigh-ups are hard to make, but they are not impossible to make. So, for instance, like we gave you the example of in all negligence cases you need to make that weigh-up, and we would say that is also true of war more broadly. Like, clearly people understand that soldiers occasionally die. We would note that actually what people don't understand is the kind of general kind of death by 1,000 cuts that soldiers go through, which, for instance, is exacerbated by the fact they might be in bad conditions or the fact that they might not have proper psychological care. We actually think that those are the issues that are most likely to be brought forward to this court. So, for instance, why was it that I was on watch for 12 hours a day needing to wonder whether or not a suicide bomber would come up to our base, but that was not deemed as something that I needed a counsellor as a military person because I didn't have to see violence. We think that those are the kind of things that these courts would be able to negotiate, and a military court is never going to be sufficient to negotiate that because it is sort of by definition just defined by whatever the general status quo is within the military, and it's likely to be particularly regressive in that way. Why is it that we think that the trials, or at least the potential for trials, have the ability to achieve good? First of all, on how these trials would actually be conducted. Opening opposition wants to say that there'd be an incentive to say destroy evidence or all of this. As is noted, we think that this toes a very fine line, because if they want to say that military courts are a reasonable threat that is able to deter people and able to make people behave in an appropriate way, it is unclear why this would be for any individual general the thing that tipped them over. The best response here is to say, well, the idea is that the whole military would be able to get around destroying this evidence. The first thing to say here is we think in some cases it is not obvious to the military that they are doing something that is wrong, and therefore we think that these proceedings are an important way to say, for instance, draw to their attention that there is improper provision. Second of all, in the instance where something is going largely wrong, we think it would be easier to deal with that problem, for instance, provide counsellors, than take the risk of having this court being taken, especially when the option that opening opposition puts forward is at one point like killing a soldier who might potentially speak out. That is exactly the kind of thing that would be a huge risk for the military to do, and they would be unlikely to take, because that would be particularly bad. The final thing to say here, though, is that we also think that this idea that the military would sort of like unionize in an ability to hide this idea, like assumes, like if the military was willing to hide something, then it's kind of unclear who it is that's bringing the case. Like, clearly there is a critical mass of people who might bring this case and therefore would also be able to bring the evidence because, for instance, they would have been able to see it. But also there are clearly issues with destroying evidence, like the fact there's a big hole, like, well, like you know, you can't like forge the fact you employed someone or say you did something else. On the idea of military strategy, like the first obvious response is like, you could also be punished for omitting to, for instance, do a perimeter check that when then meant that you were vulnerable. It's very likely that you will still be doing the same things people go. But secondly, we think that people go into the military because they'll be doing good. And also they understand that soldiers go into the military because they want to be like military people, and therefore will, I think, understand, at least unconsciously, that the kind of things which soldiers will be cranky about will be things that deep down they know they should be cranky about, not, for instance, tough tactical decisions. To the extent that, for instance, it means that they are worried about making tough tactical decisions, we think that actually it means you're more likely to, for instance, deal with veterans either potentially in the military court so that they don't get cranky, or give them, for instance, a good pension, which means they're less likely to need to sue the state. So if you do make a decision, it means that you deal with it preemptively. We would also say more broadly that reform is more likely responding to opening opposition, because it's not that seeing these cases make you not want to reform, it's that they are an instigator for reform, which is exactly, for instance, how class action suits work, which is that the problem is hidden, and then you see people agitating for change and agitate for that structural reform so that those class action suits don't need to happen in the future. Closing.
Given it's extremely likely the government is going to be exonerated because they can hire the expert witnesses far better than the claimants can, won't this just justify and legitimise all of the potentially questionable tactics you guys are talking about?
Yeah, so we've preemptively responded to this at Emily, which is that currently military support, when it's broadly homogenous and the soldiers are the same as the military, which is the same as the government, does mean that you exonerate those decisions. In splitting the people who are actually fighting from the war to the people who are in Washington, we actually think that public support and therefore funding for things like expert witnesses does go to the soldiers, because it's not actually a power imbalance just squarely in money. It's also, first of all, just a power imbalance of fact, and if you've done something shitty, that could be found in a court of law, no matter like how fancy your lawyer is. But second of all, like fancy lawyers don't just like increase like endlessly getting better. We think that both the soldiers would be pretty cashed up, Washington would be pretty cashed up, and the way in which nationalist sentiment actually works in these court cases, we think would often be for the soldiers, because it is the veterans people care about, not the people in the situation room. And that. But even if to some extent this does legitimise questionable decisions, you have to prove why that legitimisation is necessarily bad. Because if people think that they have made a legitimate decision, we would prefer that to be discussed democratically and decided upon, rather than hidden from new people going into the military, hidden from the population who are then, for instance, in general elections voting on the war. And that is another reason why it is abhorrent that these things are just kept out of the limelight or in military courts. That is why we propose.
There are 250,000 people dead in Syria, and the US does nothing except drop bombs on them and fund militants that end up being Islamists. We pulled out of Iraq and Afghanistan without resolving their conflicts and without installing sustainable institutions when the death tolls of our troops hit the thousands. The problem isn't, as OG contends, that we don't care about our troops. It's that we care about them too much at the expense of other actors. When we give generals an additional selfish incentive to care about them too much, we pull out of those conflicts, we don't enter them, we conduct them through bombs rather than diplomacy and troops on the ground and winning hearts and minds. We make the whole world a better place in a failed effort to help a few troops get some money and better working conditions. Two questions in this debate. Firstly, will we get justice for those troops, the only stakeholder they wanted to engage with? And secondly, how does doing so affect our conduct of war? Firstly, on justice. The first thing to note here is that opening government hugely exaggerated the nature of the problem here. Yeah, they tried to establish a crisis where generals don't care about soldiers, they deprive them of access to psychological services, and they consistently put them in dangerous situations. They don't respond to most of the 5 reasons that Ollie gives you, which I didn't write them down, but they all sounded good. And there was something to do with how these generals were soldiers themselves 15 years ago, so they probably had a lot of empathy for those people and know what it's like to be put in a situation of neglect. The narrative that soldiers are heroes and are the most important people for us to protect that exists all through society, but especially in the military, and also things like political pressure from your superiors and politicians that aren't going to use your branch of the military, for example, if you keep doing stuff that seems neglectful, even if we haven't proved it in a court of law. But even accepting that this is a problem to some extent, we gave you a number of reasons why it would be very difficult to prosecute those cases successfully and achieve the material form of the justice that they said was principally important. The first reason was that they would hugely restrict our access to evidence about the case. We told you that the military was uniquely unlikely to cooperate with civilian courts for reasons different to courts within the military, because those civilian courts and those judges were seen as fundamentally removed from the realities of war and failing to understand them. They couldn't possibly possibly understand what your general was going through when they had to make a choice in which either way people would die when they were surviving on 1 hour of sleep. So why would you give up that information to them in order to let them make that judgment? It looks like things like worrying about your secrets getting leaked and then undermining the military project. Because civilians don't know what to fucking do with sensitive information. They don't know how to avoid talking to their friends and families, and that information can always get out to the enemy. That means that they would withhold evidence and destroy records, which is the only thing that Imogen responded to. She was like, well, destroying records means that there's a hole in the record, and that might be indication that you did something wrong. But like, obviously generals can do it in a smarter way, rather than just like destroying page 5 and leaving all the page numbers in a row. That means like things like not putting your communications in writing in the first place, which A, means you can't hold them to account, and B, means that you don't have like clear communications about what's going on in the military, which can undermine them. It's things like pressuring your soldiers not to testify in courts, and there are all sorts of awful ways of doing that are much worse than negligence itself. That looks like code reds in which they are bullied or told that they'll be put on the front lines unless they don't go to the courts, and that's in itself a harm that they create when they try to solve that other one. But thirdly, we told you that this forecloses on alternative paths to justice, because military courts, yes, are imperfect, but they get justice all the time in like a micro level at least, of holding people to account for, like, for example, criminal cases of negligence within the military. And this disincentivizes that form of prosecution because it might bring up evidence that can be tabulated and then subpoenaed by a civil court that will then be used to like undermine A, the security of that military, and B, the integrity of its leadership. And Imogen was like, well, it feels a bit evil that this occurs in secret. A, it's not completely secret, right? Like when there are scandals, like we do have inquests into the military, that doesn't involve completely revoking their capacity to punish themselves, which means that they would withhold the evidence, but we do have some oversight. But also, their alternative is just a super inconsistent form of justice, where if the general manages to cover up the crime, then they don't get punished. But also, we told you that this form of justice was a very individual one, where yes, you can get recompense because for you or your class of soldiers was involved in a specific act of negligence, that doesn't lead to fundamental change, and in fact may absolve the obligation of the government to provide care for all its soldiers, because they can be like, well, we paid for the damage, even though paying for it after it happens is obviously not preferable to resolving it. They were like, well, it creates an incentive to change, but we think there are, like, as in general, because you don't want the cases to happen in the future, but we think there are a bunch of incentives to change and a bunch of like alternative ways that we can get this. Like, if it's true that soldiers don't get counseling in the military, like, people fucking love soldiers, especially in the United States. Like, that's the kind of thing that you can get like veterans associations to campaign the government for. No, the GI Bill was the single biggest like piece of welfare in American history. We think that these soldiers aren't, like, in general, that poorly cared for. Closing? Opening? Someone?
The point though is that as long as this is happening in secret and defined by the military, it can't change. The more and more that people have to cover things up or say that what they're doing is reasonable, isn't it actually just easier for, even if there's one case, for then reform to cascade from there?
Yeah, so the problem is that they suggest that it's an imperfect system, but don't give us a clear path to recovery. Because if it is one case every now and then you do have an isolated instance of a general falling from grace that doesn't reform the system. And also we told you that there are alternative mechanisms of reform, such as inquiries when a specific bad thing happens, where you can encourage the military to reform without saying, we're taking your entire power of jurisprudence away from you, which is likely to create opportunities for antagonism between those two parties. Secondly, and more importantly, how it worsens our conduct of war. And here's where they didn't engage with us enough. Because we told you that this exacerbates an existing bias towards not intervening in other countries, which is problematic because often those countries are going through human rights crises. There is no meaningful distinction between acts and omissions, which means that we are as responsible for the deaths of civilians in Syria as we are for the deaths of our troops and their troops when we go in, yet we are constantly biased in favour of the latter thing because we care more about our troops and we don't want to be seen to be directly responsible. We told you this problem is worsened when they are opened up to liability, because now you put yourself in the position of negligence rather than just troops that you care about also in that. And Imogen tried to make this a contradiction, which was clever, because she said, well, we said that they would just hide all the evidence, so how does the mechanism work for us? We don't think you want to have to hide the evidence, right? You don't want to have to destroy evidence every time a negligence case comes up. You don't want to expose yourself to that. You don't want to have to go into court and testify all the time. We don't think this is a sufficient deterrent we don't think this is a sufficient deterrent to mean that you won't hide the evidence when like one-off things happen, like you didn't give your soldiers counselling, but it will mean that going forward, you don't want to like get yourself into a war where you're likely to bring yourself up into all of those issues. But secondly, we told you that this exacerbates the bias towards our own troops, which is extremely problematic because it means we use tactics like carpet bombing and drones, which A, just kill people rather than like actually taking over a country when that's necessary and getting rid of like the evil militant group that's captured it, but also B, mean that we're incapable of winning over hearts and minds, and we're seen as the alien imperialist oppressor. For those reasons, this ruins the military. It doesn't redress the injustice of soldiers. We win the debate.
2 prongs of extension. Firstly, on why the counterfactual of military court is fundamentally ill-equipped to deal with these specific cases of negligence. And secondly, on why this means that the military is likely to reform in better ways. Lastly, I'll do quickly with that. I just want to do a little bit of modelling from CG. This is like really reflective of the military court debate, and I was also modelling from there as well. But we think this will run like the Australian model. I would note that this is the status quo in Australia. There's a military rehab and compensation commission that exists at the moment, that if you want to launch a civil suit in Australia, you go to them, they investigate for you, it proceeds in civil court. This provides a really easy way to protect state secrets, as they said, because it allows for things to be redacted. Which we already have precedents for. We redact things all the time for things like native title and for sensitive defamation cases and things like that. But also, it means that it forces cooperation because the military has to cooperate because they are an independent arm of the government, and so if they're unable to not do that without receiving significant sanction from the government. I would note that Australia has many successful court cases ranging from everything to the rashes caused by the uniform were like uncomfortable to really significant instances of negligence. So that is the model that we would propose there, which I think alleviates a lot of their concerns. Let's look at the counterfactual of the military court. Often it is simply unable to hear these cases, and that is true for 4 reasons. Firstly, often these cases are brought by people that have been discharged from the military, and that is because often the reason you want to sue is because you've suffered, for example, a massive injury due to poor operation, which might mean that your helicopter crashed when it ought not have, or that means that you were ambushed when it should not have been, or anything like that, which means that you've suffered a medical or psychological injury, so you're literally not a military personnel, you're a veteran, which means you're unable to access that mechanism in military court. Secondly, the government cannot be taken to military court, like you can only, it's just, you can't do it. Thirdly, it happens after the fact. Military court stands whilst a operative, like, operation is happening, which means that you kind of like a post-fact military court unless you're continuing to be in that military, which means that often the teams are disbanded by then, the soldiers groups are hard, it's hard to assemble people to be witnesses because they've already been deployed on other missions. And fourthly, there's simply no adequate form of sanction. Like, you can strip people's rank, you can suspend them without pay, but you can't get compensation from the fact that you no longer have a leg, for example, or that you incurred cancer from a chemical that wasn't tested adequately by the government. And that just seems like a really mismatch in terms of priority, in terms of what opening opposition want to do. The second thing to say is, so what that means is the types of cases that you actually hear in this court are heard during the theatre of war by people who have likely experienced a significant injury at the point of the most extreme disadvantage, which means that they are least likely going to be able to succeed. And there are 4 reasons why that is true. The first thing to say is that it is often attacking dominant power structures, such as generals who are literally present and people who still control you while that is the case. For example, if this happens on the Navy, the ship is literally still sailing, you are still in Iraq, for example, you still have to respond to these people in real life, you don't get like special amnesty or whatever while your case is happening, you still have to do it. And that is responsive to opening opposition thing of like, oh, but they have empathy because they used to be a soldier. The judge has empathy for the decision maker because they are currently the decision maker. They can see themselves making that decision in another instance because the people who are judges in military court cases are ex-military generals. They are not soldiers. They are people who are running their cases. Secondly, there are no lawyers for these cases, and negligence is a particularly complex suit. I just think like we've probably done it all wrong, and we're over half of us are law students. Imagine if you're just like a chump who joined the military, you're probably not going to be able to articulate the specific military doctrine of negligence in ways that are particularly compelling, particularly when you're against people that are much older than you. Often the people who get fucked on the most of poor decisions are your grunt soldiers. They're not the people in the top tiers of power. They're the least able to articulate themselves and make sure that it's heard. They literally just find the person who is like best equipped to do it, which is usually just like another person who is also 22, who's also not trained in law. The third thing to say here is that it occurs mid-theatre of war, and that is significant because that is the height of when everyone is most convinced that the mission is good, because you have to be, because you're on the mission, and you really like having a hit for morale if you're got this one dude that's like, fuck this mission, and then everyone's like, no, we have to be on the mission for another 4 years. So there's strong incentives to perpetuate the narrative that this mission is worthwhile. Often people might be mourning people who were lost on that mission should they wish to bring the suit's case, in which case there's a strong incentive to say they died for a reason, their sacrifice wasn't for nothing, in which case there is an even stronger incentive to shut these things down. The last thing to say is that military courts just simply weren't designed to handle these sorts of cases. They're designed to handle relatively small crimes. For example, getting into a fight with a fellow officer or drinking on the job and things like that. And that is because military courts, unlike the civilian system, happen immediately. You don't have to wait until you come back from Iraq 5 years later to try the case, which means that they just simply no jurisprudence like they wanted to talk about in the same sense. There's not the same infrastructure or legal information available to you. They can't even get a third party to hear them out and understand their case. They're unlikely to happen in that way. That's why the sanctions are so small. Yes.
Just say we're agnostic as to whether people go to military court for the reasons you provide, such as the fact that they're all invested in the mission. Doesn't then most of your speech fall out of the debate if that's not really what we have to stand for?
Well, it's unclear what you're going to stand for because the other alternative is civil courts. And your opening opposition have decided that that's what you're going to do. So it's a little rough. The fourth point, well, your two courts are like the court. And then this military court. So now we're going to talk about the military court. Then we talked about the military court, now we're talking about the other court. Let's look at civil cases. Unless you're going to try them criminally, in which case, good luck. The first thing to say here is that negligence is often better trialed in civil suits because we can do things like publish transcripts and increase transparency in that way. The second thing to say is these civil cases allow for acknowledging the fallibility of the government in the military, which is incredibly hard to question, particularly in the theatre of war, but also for civilians. So when this actually goes forward, people are likely to question the dominant forms of the military and the exercises they go in. The third thing to say, and I think one of the most important, is that you actually get a proper lawyer. You get external advice from people who aren't literally on the same ship as you or in the same platoon as you, who have extreme incentives to suck up to the generals, who might be personal friends with the generals. In fact, the people your hierarchy tells you to consult are your mentors, which are also just generals. So it is someone outside of that structure who's trained in the law who's likely to tell you that your case can go ahead. That means that you can also access things like extra funding because there are veterans organisations who will help you take these claims to court. People like the ACLU are likely to want to fund these cases as well, and community legal centres are also available when you're outside of the thing of the military. So when you're actually able to take these cases to civil court, that can happen better there. The last recompense you can get is through the form of a settlement because you can't actually get that in military court. You can take, even if it is like whatever, they're like it's a crackdown mission, I would prefer the person who is living their life with a terrible medical condition because their general cooked it to actually get some money to make sure that they can live their life in a good way. Very quickly, why does it make the military better? Firstly, it stops the incentive to immediately discharge people to avoid prosecution. At the moment, that is what currently happens. The second thing to say is it encourages individual soldiers to rethink events that happen to them. That is why opening opposition's claim of bombs or whatever was not relevant. Negligence is in general to specific roles. This is the government fucking up. This is generals fucking up, and this is what was specific about this debate. And that's why civil courts were the only mechanism available.
I'm going to talk about three things in this speech. Firstly, dealing with the two prongs of opposing government's extension. Secondly, explaining how the military would behave and why that would occur in the worst way. And then secondly, explaining why the government would behave in the worst way as a result of this policy. Firstly, on opposing government's extension. So the first prong, which I spent the majority of the time on, was the idea that military courts are ill-equipped for the same types of suits that they wish for us to pursue. I think the first thing to note is that we aren't suing the military in military courts for negligence. So the question of which side would be better at, suing for negligence is immaterial because you're not suing for the tort in that military court. You're suing for you're seeking a resolution of civil disputes in a far different way. The second thing they tell us is that you have no experience in military courts as opposed to being able to hire incredibly good lawyers in civil courts. I would suggest that if they'd seen a few good men, we know that we have JAGs, as in, the person who Tom Cruise played, that advocate on the behalf of people who have been wronged in those courts. And those are people who also went to law school, who actually perhaps have a better understanding of the military than your average lawyer would. So perhaps in some cases are actually more equipped to advocate for those individuals. But no, thank you. I just have sort of three broad, thoughts about this extension. Firstly, we don't have to support going to court in general, and in fact from closing opposition we're going to suggest that this policy makes things worse than the status quo, and that is the reason in itself not to put this policy in place. Secondly, their entire extension here relies on people coming forward to the courts in the first place, and let's note their model. So I don't think you can be like the model we have in Australia will be implemented in the same way in jurisdictions that are different all around the world, because the attitudes toward the military, the way in which policies are implemented are different in the United States than they are to Australia. They're different in Indonesia than they are to Australia. They're different in Saudi Arabia than they are to Australia. So I think it's unreasonable for this side to be like, we will implement the most progressive version of the implementation of this in every single jurisdiction around the world. The last thing they talk about is the military would be better because right now, for example, they would discharge people who are threats so that they could not sue them in court. This is really important because this incentive still exists and actually now manifests in a proactive solution to that problem, which I'm going to talk about later. It changes the recruiting and hiring practices of militaries, and that's particularly harmful. Let's now talk about how the military will behave. We're going to talk about three things in extension here. Firstly, on indoctrination of soldiers. Opening opposition tell you that the military will intimidate and kill soldiers. We say the military will begin a program of indoctrination of their soldiers to an even greater extent than they do right now. And go, thank you, in order to instill those values of camaraderie and the idea that suing the government or suing the military is tantamount to treason. Look at the way in which the vast majority of governments treat whistleblowers. They imprison them, they vilify them, they view them as national traitors, not as people who are heroes, as the other team wanted to say, even if they're members of the military. Look at Chelsea Manning. The next thing to say is that, and that also then leads to this idea of selectively promoting and selectively hiring people who perhaps could speak out, which I'll talk about in a second. Now I want to talk about tactics and strategy, because this was the really big push that we hear from opening government. Opening governments say, and the question here is, can judges actually make proper decisions on military tactics and strategy? I don't think that they're qualified to do so. Opening government's solution to this problem is utilising expert witnesses. But firstly, as we point out in the POI, obviously the military will have far more capacity to use those types of witnesses and far more legitimacy to use those witnesses. Imogen's response to that is saying, well, public support will mean that there's lots of funding for these soldiers, so they're able to compete on a financial ground. But that ignores the other reasons for why expert witnesses and expert witnesses with more legitimacy are more likely to advocate for the military and the government than they are for individual soldiers. Firstly, I would suggest that expert witnesses are less likely to go against their own, i.e. other generals and people that they've been in the military with. Secondly, experts don't want to burn their bridges with the military and the governments of their country, which this would be tantamount to doing. But thirdly, they obviously strongly believe in the idea of general discretion and the idea that, every type of thing is different. So I think when judges hear the vast majority of evidence actually coming in support of these generals, that means they're more likely to find in favour of those generals, and the impact here for opening government is that those tactics they want to get interrogated actually become legitimised. The other reason they're more likely to find out about it is the way in which judicial appointments change, and I'll talk about that in a second. No, thank you. Now on hiring and recruiting. The potential for this avenue of redress increases the incentive for the military and the government to begin selective and discriminatory practices such as not hiring as many women, not hiring trans individuals, not hiring people that they suspect to be homosexual. The harm of this is threefold. Firstly, it's a harm to those individuals themselves. B, it is a harm to current members of those communities who are already in the military. And thirdly, it is an increase in the toxicity of the military, especially in the leadership of the military, because less individuals from those communities are likely to rise up into positions of power, because those are the ones who transgressions are most likely to occur to, and that is particularly harmful and something that, as closing government notes, the military would want to stop and therefore would proactively do it now, as opposed to, so going over.
A significant portion of these cases will just be about conditions or service provision. Why shouldn't soldiers have the right to argue in a court of law for reasonable provisions like any other worker?
Okay, yeah, so the thing I'm going to get to now is, it talks about this. So what's a better use of political capital here? This seems like a rather indirect way to get all of that kind of reform. Why wouldn't we just put all of the same level of political capital to use this policy to actually trying to establish legislation and actually improve the conditions that we're talking about in this debate? Now, judicial appointments. This is incredibly important. The incentive to stack judiciaries with military and government-friendly judges becomes massive. Right now, these things are dealt by with military courts, but this dramatically changes the calculus and affects the process. Why? 1. Governments care significantly about the military and its perception and reputation. 2. There are very strong electoral incentives tied to this. 3. This is relevant for almost all potential political governing parties all around the world, no matter who's in power. 4. They don't want to lose and open up the floodgates. What is the impact of this? That means that A, trials that do occur are extremely likely to garner not guilty verdicts. B, they're able to be targeted in states where there are big military bases where the vast majority of suits are likely to occur if they do occur. And the impact of this in the debate is if we can prove that the judiciary itself will be stacked in favour of the military, this is a self-defeating policy and something that would obviously make things worse. It undercuts every single mechanism that every single Gov team has pointed out, and I think wins us the debate. Proud to oppose.
Incredibly assertive, and I think it's going to cost them. Starting with their extension, then on opening opposition, then on our extension, defending it a little bit, but it doesn't need a lot, and then on why we'd be affecting government as a result. First, on that extension. The first problem with the extension is to say militaries will indoctrinate these people to a greater extent. 4 responses. First, it is unclear why you make this incentive greater than it already is, since you can see that this incentive already exists. Second, like this actually increases your negligence to a much, much higher degree because that itself is contributory to the fact that you've been negligent in that instance and that you've indoctrinated them to not come forward about the incident. Third, you need to be comparative. We get the side in which you see the fallibility and that have a signaling mechanism that says these militaries can in fact be fallible, which makes it a lot easier for you to come forward than in your world. Fourth, obviously the media generated by this is just extraordinarily bad and leads to all the sorts of pressures that opening opposition clearly identifies are extraordinarily negative. Fifth, we are the team that obviously groups people in positions, which means that once 1 or 2 people start to go forward, based on class actions, it becomes easier for everyone to go forward. The second part of their extension, there are 3, is to say we get bad expert witnesses. This is extraordinarily assertive, which is a trend in Romaan's speech. I first want to establish that there is a huge level of scrutiny established for expert witnesses, which makes sense, right? They are expert witnesses in an open court of law at the point in which you have on your resume as a disclosure, I used to work in the military industrial complex or whatever they're talking about. It means extraordinarily unlikely that your evidence is likely to be taken seriously at all. But obviously we are the team at closing government that establishes that we can get resources to adequately contest those findings, to get our own expert witnesses in order to contest that. Like obviously these are likely to be people who are scholars. The assertion that this is going to be ex-generals standing up being like, oh my boys, this is how we usually do it, is just bizarre. Third, and this is where they spend a lot of time, which is unfortunate because it's particularly bad, is that this leads to bad recruitment for judicial appointments. Just consider how long this bow is and how few mechanisms there are. Because the way judicial appointments work is it's not like the general is able to make these sorts of decisions. There is a huge flow of incentives and different people acting in between that is never established. Why is the governor of Kansas or whoever within these district courts somehow going to be adequately lobbied in the way in which you describe without any sort of transparency? It's just not proven. Second, there's a tiny chance that this individual judge who appointed this court hears the specific military civil case that you were describing. You again, just do not prove the link. These aren't specific military civil courts. Third, as acknowledged, these incentives already exist to not appoint gay people or women, as you seem to suggest. Presumably it's unclear why you ship those more. But fourth, you also just have every other incentive to appoint good judges, people who you think are going to find good facts so that they reflect well on you as a governor or a president or whatever. Notice well, fifthly, those decisions come under a huge amount of scrutiny. It's really easy to get up in the state legislature and be like, what the fuck? Why does you appoint that ex-general to be the civil case guy? What the fuck? Okay, so there are the debate, that was terrible. Second, OO. There are 3 claims of OO. First, evidence will be destroyed. Second, you get worse war. I think maybe that's the 2 of them. Oh, then there are other incentives. First, evidence will be destroyed. 5 responses. First, these cases are on the balance of probabilities. You need far less evidence. Second, it's extraordinarily suspicious when this evidence just ceases to exist. Where are the command logs from this night? We subpoenaed you. Oh, they don't exist anymore. Sorry, guys. That this itself is also often evidence for the negligence you suggest, because negligence can take that into account as an omission is still able to be seen. But also, it was like, well, there are reputational reasons. But those reputational reasons also cover for the exact situation they're describing. Oh, yeah. Third, a lot of evidence can't be destroyed, which just destroys their entire point. You can't just like kill eyewitnesses even though they seem to think you can. Those people do, yeah, I know, like, those people do still get their day in court. You can't just like do whatever they seem to describe, then evidence and apply to that. Fourth, as we established in our extension, there's now an acknowledgement of fallibility. It deconstructs the mythos of the military, which makes it extremely easy for these people to come forward. Fifth, like just be comparative. Ollie concedes in the POI that this evidence is often destroyed within these courts. It's much easier when that is a closed court because there is no system of appeal. The people there are all military officials and discharged soldiers. Those systems are already in place. Second, there are other incentives, things like reputation and loyalty. Second, note that this debate obviously takes place on the margins where those incentives have failed, so like that is a wash. But second, that it is a basis to not have any negligence law is to be like, oh well, that shopkeeper had incentives to not have that woman fall through her floor. Yeah, those incentives always exist. Third, they're worse war than that's gonna happen. First, evidence gets leaked. Obviously, as we establish in closing government, things like trade secrets, things like customary law in Indigenous native title cases are often that specific evidence is suppressed. That was a no-brainer. The second thing they say is that it's sometimes better to not be cautious in war. This team fundamentally misunderstands how negligence law works. It is not sufficient just to say, oh, someone was harmed in war. You need to prove that the duty of care existed and that you earned in that, and they are sufficiently high tests which you guys just never grapple with. It is not enough to say, oh, I got shot in war. You need to establish that your general should have acted in a different way, or whoever gave those orders should have acted in a different way, which means that fundamentally your mechanism just doesn't manifest. Yeah, I'll take you, Imogen.
Yeah, so with the Sierra Leone Civil War, militants advanced on the undefended capital with intent to massacre its inhabitants. The British Army deployed a few thousand troops and prevented the atrocity. Would this intervention have been more or less likely if generals knew that they would be liable to pay out millions of dollars if they were found to have breached that duty of care?
I think it's probably equally as likely because A, there are probably all the incentives you already acknowledge for that thing to happen, but B, it is extremely unlikely that they think they would be negligent because they can probably say, hey look, here's all the training we did, here's all the fact-checking we did about this thing, therefore we're probably in the clear. So unfortunately that highlights your failure in the debate, I think, rather than winning you its material. Thirdly, in terms of our extension, we established a lot of stuff with respect to why military courts can't deal with these cases, why they handle them poorly, how they're not designed for this, and why the civil cases, etc. are better. The responses to our extension are paltry. First, they say, oh, we're not suing for negligence. Obviously, this is a comparative similar thing within the military courts. That's obvious. Second, you still have JAGs. They're obviously incorporated in the military culture and allocated by the military to specific cases and also are discretionary in that allocation. Third, people won't come forward. Firstly, we get more people because they get financial reward. Second, as we establish the fallibility. But third, we establish a reasonable model at CG which makes people more likely to come forward. And then I obviously already dealt with their discharge stuff. So finally then, given our extension survives, why do we also get up over opening government, given that these teams don't understand good things in the debate? They rely wildly on an uncomparative world. They are unable to assume the counterfactual is nothing. They do not give reasons why and grapple with the counterfactual of military courts, and that's only something that we do. So note that their harms and benefits in the debate don't really carry until our analysis, which grapples with the thing that is actually suggested by the opening opposition, even though closing opposition decides to move away from it. At the end of this speech, incredibly proud to propose.
That government misses about this debate. This isn't about, given a negligence case is inevitable, where shall it take place? This is about acknowledging a reality that exists in this debate, which is as follows. Every single soldier in every single army in every single country on earth is a victim of negligence. Because if my employer were to put me in a situation where I might have my leg removed by a landmine, where I am at risk of suffering psychological harm every single day, where pain and suffering for the rest of my life are almost part of my job description, that employer has been negligent towards me. Which is why it is nonsensical to force individual soldiers to pursue negligence claims against their employers, because all of them deserve this form of compensation. All of them deserve state support support to be ongoing, and all of them deserve what we provide you on opposition, which is broad public support for things like veteran affairs regimes, which give them the compensation every single one of them deserve, and not the rare few who are willing to stand up against a structure that they were willing to die for. Few things I'm going to do in this speech. Firstly, why do they all deserve this, and therefore why does this model make no sense? And secondly, are these cases likely to be successful, and therefore, if not, why does none of this make sense either? Firstly, we stand for military recompense for wrongs being given to every single military veteran who likely suffers wrongs as a result of the inherent requirements of their job. Why do we get that under our side of the house? We get more public support and funding by the very mechanism that OG helpfully explains very well to us, which is that what this does is it dislocates support for soldiers from support from a broader military structure in highly nationalistic states, which means people's alliances to one or the other are now split under their side of the house, but also they believe that these people would be able to have like recompense if they chose to. So, does every soldier face these risks? Yes, because every single one of them is like attached to a risk of having poor conditions. Like under their side of the house, they wanted to say that like sometimes you won't be given enough food, and sometimes you might be in uncomfortable positions. Yes, you are in a war zone. You might be killed at any point. There's not a single soldier who does not face this. It does not make sense to make each of them pursue this individually. But secondly, it indicates that if the conditions were bad enough, you had legal recourse to sue for negligence, and you have chosen not to pursue that particular avenue, which means public support, even to the extent that it isn't splintered between different parties in this debate, is still undermined because people believe that veteran compensation in general is not necessary anymore because the people who are wronged are able to go directly to court. This puts soldiers in a really bad position because, as Romaan identifies the insufficient response, you're in this awful position where you're probably inculcated by the military to believe it is akin to treason to sue the country you are willing to die for. Their only response to that is to say, well, it's even more negligent if you inculcate them, ain't it? Well, yes, but you don't write down culture construction on a document that can be subpoenaed. It's far more insidious than that. It's how you make these people believe what their role is. It's how you make these people believe what their duties to others are. It means that if you want to go to court, it is your friends who are on tour with you, who are willing to die with and for you, who now have to be subpoenaed to give evidence against a government and a country and a military that they love. That's going to alienate you from your support structures back home. That's going to make it harder for you to live your life afterwards, which means you're in a position where you're no longer default entitled to the recompense you deserve because you suffered wrongs at the hands of your government, but you are no longer able to realistically pursue this option in a lot of cases because it means putting your friends in that position, because you yourself have internalized the messages of the military that to sue your government is an act of treason, and it wasn't enough in this debate to say the court that they wouldn't do it just because it would be bad or because it would be discovered. Why are courts bad at making decisions? It's because of a really simple reason, and it's not about like which military generals will we call to give evidence. It's because negligence law literally breaks down when you try to talk about the military, yeah? Because if my employer did anything to me that the soldier has to do every single day, it's obviously negligent, and they're obviously going to be sued for millions of dollars. This law does just not apply to these people in the same way because all of them have suffered. But secondly, this doesn't just affect general decisions that generals will make in entering wars or in how they approach wars more broadly, like whether or not to invade a country or to carpet bomb a country. It affects individual generals' decision makings in ways that are disastrous. Because when you know that you as an individual officer could be personally liable for millions of dollars if your particular strategic decision in a tiny instance does not satisfy your duty of care to your soldiers, you're far more likely to do things that will kill loads of civilians. The only responses we get to this from closing are to say, but you're likely to consider whether or not you've had training and whether or not you can exculpate yourself. That
only operates in terms of the logic of our opening when they talk about governments making decisions and high-ranking officials making decisions. We tell you that lower-ranking generals make choices every single day about whether or not they will enter. They have to do it in really small amounts of time. They're likely not legally trained and highly stressed. They will now always err on the side of things that kill civilians rather than erring on the side of things that are able, no thank you, that are able to like keep the most people alive. Are these cases likely to be successful? OG tells us it's easy because you get public support for nationalistic sentiment and soldiers. Couple of problems. First, if people aren't willing to bring the cases because they've been indoctrinated against it, that does not matter anyway. Secondly, the glory of military lies in suffering for your country and that being something worthy of valor. That is why people support the military. These particular individuals are likely to not get that support because they're considered as being too weak, as not willing to suffer for their country, as not willing to do what they signed up to do. Secondly, it's not about them destroying or hiding evidence, it's about what closing points do. Heavy redactions of all of the documents that are going to be evidence in this case, which makes it functionally unreadable, which means they don't need to have these like secret nefarious buryings of evidence. They say this is national security, we need to redact, which means none of these cases can be prosecuted. Thirdly, judicial appointments in key areas such as Maryland and Virginia will be used to set precedents for the entire country because that's where military bases are. The government is the one who can be sued for billions of dollars in a jurisdiction that has excessive damages for tort. That means they have an incentive to stack this out and the government can control it. At the end of this, they got nothing for veterans except undermining the compensation every single one of them deserves. Proud to oppose.